Okay, hi everyone. My name is Attorney Alex. I am supervising attorney with Egan Immigration. I'm here to answer any questions, concerns, talk about any issues folks are seeing today. So please share your questions in the comments and chats here. I can share a little bit about what we're doing at Egan right now. We are working on our usual humanitarian and family-based applications. So if you have questions about a family member petitioning for you, if you have questions about how, different past work experiences might give you a pathway to a visa and your green card, please give us a call. Our number is listed on the little background image on here. You see our number there, so please call us. We can do an evaluation and a consultation. We are also opening up services for removal defense. So if you have an immigration court hearing, you've received a notice from immigration court, anything like that, please give us a call. We can help you navigate that, represent you in court. So please give us a call if you have any questions or concerns. Okay, so I see some questions are coming in. Let me take a look. So I see a question about a situation where you have been paroled into the U.S., you may be using the CBP1 app or another way. Basically, an immigration officer let you into the country when you first entered here, and now there's a question of, I'm about to marry my U.S. citizen partner. Will I have to leave the country to complete that process? So each case is really different, but with just these few details, generally if you were allowed into the US, you had an admission, you don't necessarily need to leave the country. So again, every case is different, so please give us a call at the number on the screen and we can give you more detailed information. But if you do marry a U.S. citizen and you have a lawful entry into the U.S., you can stay inside the country to complete your process and get your residency. You may not need to leave. So it's a very nice exception, and we will need to evaluate your full case. So please call us and we can answer more questions about that specific to your case. Okay, looking for other questions coming in. Let's see. So I see questions about someone has someone's green card, their residency card has expired, and they have filed to renew it, and they have an extension, and they're asking if a copy of that extension will help protect against if they're stopped by immigration in any way or by a police. Yes, I always suggest that people carry proof of their immigration status or proof of an application that's in process. Please carry that on you as a sort of protection in case you are stopped by immigration or stopped by law enforcement in any way. You can show your lawful status. That may prevent a detention, or if you are arrested and detained, you can still show that to an officer, and that may help get you out of detention faster. So yes, if you have filed to renew your green card, carry a copy of that extension notice on you, and You do have your residency, that is your status. You just don't have the current card. It's kind of like, sort of like you could compare it to like a driver's license. Like you may have the qualifications for a driver's license. If you've applied for it one time and you need to renew it, it might be expired, but you just need to renew it. You don't have to go through the whole driver's license application process again. Um, you haven't lost that driver's license eligibility. So it's a similar thing with your green card. You still have your residency. You just don't have the valid card, like the physical card to show law enforcement that you have that status. So definitely carry if you have the old card, carry that or a copy of it, and also the receipt notices and the extension notice on you, so you can show that to anyone who may stop you. I see a question about processing times on family-based applications in 2025. So process times, unfortunately, are pretty slow. I don't see them moving that much faster than they were last year under a different administration. They are going at about the same pace. I will look up processing times for a case right now. Let me do that while online with you. So I will use as an example an adjustment of status application. So that's an application for a green card. I'm going to look up processing times for that based on an immediate relative, for example. And we will go out of the Virginia area. Sorry, computer's moving a little slow. Let's see. Okay, this is taking too long. I'm just going to go right from the top somewhere. So I'm going to look at Baltimore, Maryland area. For someone who's applying from around Baltimore, current processing times are at about 18 and a half months for the residency application only. So yeah, so this is after you have that first petition approved and you are now applying for the residency piece. So it is taking about a year and a half to get a decision on the residency application alone. So I consider that a long time for a year and a half for just the residency. And keep in mind that initial application, the petition for the family member before you can even start the green card process, that will also have a certain amount of time. Sometimes those can move very quickly in immigration time. So that could be about 6 months. Sometimes it could be a year or more. It's hard to give an exact time frame, but those do move a little bit faster than the residency applications. So yeah, that first step is usually about 6 months, maybe a year and a half. Then you have the residency application, which if you're in Baltimore, it takes about 18 and a half months. So you can expect about a 3 to 4 year wait from very beginning with that first petition to the residency decision. And these timeframes change depending on where you live, depending on when you file. So these times do always change, but we try to give you the best idea on timeframes every day. Okay, let me see. Okay, sorry, I'm looking through different comments. Okay, someone has asked about how long VAWA applications are taking to be approved. So I will also look that up right now. I'm on the website. Give me just one moment. So For VAWA applications, it is almost like a two-step process, but at Egan, we always try to file those two steps in one step to make it a lot faster for our clients. So the first step, when you're filing for the actual VAWA benefit, that is currently taking about, they're saying 42 and a half months. So that is over 3 years wait just for that first step for the VAWA benefit. And then to apply for the residency part, so the second step, that is taking, if you're in Baltimore, that's taking about 18 and a half months. It's usually about another year to 2 years to finish the residency. Could be less than that as well. Some offices, depending on where you live, move very quickly through those green card applications, the residency applications. But I try to estimate around a year or so for the residency piece. So yes, to answer someone's question about how long the VAWA case, the VAWA petition takes, the government is saying right now it's taking about 42 and a half months. So it is a long wait, and we at Egan share your frustration at how long those cases take. It is very, very frustrating. But we try to follow up with, we don't try, we do follow up with the government when they are taking too long to decide on those cases. So, once we reach that 42 and a half month mark, we will be following up with USCIS to see what's going on with your case. How can we get this moving faster? Can't always get a response or a decision made from USCIS doing that, but we can at least try and communicate and get them moving on your case. So, so about 42 and a half months for the VAWA application. That's the time frame they're giving today. It could change tomorrow, could be more, could be less, but right now, today, it's at 42 and a half months for the I-360. Okay, let me see if there are any other questions. So I see some questions about folks needing service for their case. They have questions about their immigration case. Please call our number. It's listed in the background on this video, 202-709-6439. Please call us. We can do an initial intake with you, a pre-evaluation at no cost, and then get you into a consultation. We are taking removal defense cases now. So if you have an immigration court hearing or you've received documents from an immigration court, please call us. We can assist you and get you into a consultation quickly and answer your questions. If someone in your family or your community is detained, has been arrested by ICE, we can answer your questions, get into a consultation, and potentially assist your family member or friend, community member, to help get them out of detention and help them with their court. Okay, so please give us a call. We are here. Let me see if there's any more questions coming in. Oh gosh, I'm moving things around on my screen. Sorry, those on TikTok. There we go. I'm trying to get through the comments to see if any questions. So I see questions about interviews. When we represent you on an application that you have to go to an interview for, so that might be for your green card, could be for citizenship, we will attend the interviews with you and we will prepare you for those interviews. We do do a very close analysis of your case and do a full preparation. If there are any questions you might have, we answer those in the prep. We do like a practice interview with you to make sure you're feeling very comfortable, or as comfortable as you can when you go into those interviews, because we realize that those can be very stressful when you go in. There's a lot of nerves. You might feel nervous going into the interviews. So we try to prepare you as much as possible to make you feel comfortable and ready for those interviews. And then we, the attorneys, will attend the interview with you and step in when any issues come up or to clarify any questions that the officers might have. So we are there for you for the interviews before to prep you, and during the interview, we are there to make sure that the interview goes well, goes smoothly. And then after the interview, we are ready to take any further action on the case if the officers need more information or anything. So we are there for you on the interviews. So I'm seeing a question about what happens to a VAWA case or maybe a family petition if a person receives it's called voluntary departure. That is it's not a removal order, but it's like a special kind of removal order where if you're put into removal proceedings, so you have to go to immigration court, a person may be able to get what's called voluntary departure, and that's like a special grant from the immigration judge to allow the person to leave the U.S. instead of receiving a removal order. So they can leave the U.S. on their own. You usually have to pay some fees to do that. And then you must leave the country within a certain amount of time. A lot of times it's like 30 days, 60 days. And then once you leave, you don't get a removal order on your background, and you have this special departure from the government. There are benefits to taking that sometimes. If you do have an immigration, or you ultimately do want to immigrate to the U.S., but you're facing certain violations and things that you can't receive a waiver on. So things that you just can't have forgiven. Then sometimes taking that voluntary departure may be a better option than remaining in the U.S. and trying to work your case through the court or whatever. So if you leave on voluntary departure, you have this, you don't have a removal order on your background. And then if you want to immigrate in the future to the US, it will be a lot easier to do that without a removal order. You just have this voluntary departure. So when you receive voluntary departure, you must leave the country. If you don't leave the country in the specified time that the judge gives you, the voluntary departure turns into a removal order. And there are extra penalties that affect you if you don't leave in time. So if you leave on voluntary departure, you could come immigrate back to the U.S. with a VAWA or with a family petition. You may need a consular process in order to re-enter the country lawfully, but there are options for you if you do take voluntary departure, and you can finish your process outside of the U.S. I will say, if you fail to leave the United States after getting a voluntary departure, there are extra penalties. If you don't leave on time, you get a removal order, and then you may be prevented from being able to ask for residency or your green card for a certain amount of time. So just keep that in mind if you are facing voluntary departure or looking at that as an option. You want to make sure you're aware of your options, the risks and consequences of if you decide to leave or not under a voluntary departure. Let's see. Okay, I see a question about past criminal history and applying for citizenship. So this question specifically is about receiving a DUI, so driving under the influence of alcohol, possibly drugs, but usually it's alcohol. So a DUI conviction can impact your eligibility for citizenship, for naturalization. But generally, if it's outside of the 5 years before you apply for citizenship, a DUI, as the law currently stands, should not prevent you from receiving your citizenship. So you should still be eligible. You should speak with an attorney before applying, though, because there can be certain details that are part of a DUI conviction or charge that could impact your eligibility, or you might need to take a few extra steps on your application for citizenship. So I do highly suggest you speak with an attorney. Please call our office. We can give you that advice and work with you to make sure that you receive your citizenship and that we are taking the right steps to overcome any challenges the government might give us on your citizenship application. So having a past conviction for a DUI does not outright prevent you from getting citizenship, but there are certain details, certain factors we need to look at to see if it could prevent you temporarily or if we need to take any extra steps to get that criminal violation waived under immigration. So please call our office and we can answer your questions more specifically. Let me see what other questions. Okay, so someone is saying that they have VAWA. They've had VAWA for a couple of years now. The question is, what happens if ICE detains me? What happens if ICE arrests me? Do I have to renew deferred action? So ICE, as everyone I'm sure is aware, ICE is increasing their enforcement. We are seeing a lot more stories about them detaining people, and it can be very, very frightening, very scary. My suggestion is, if ICE detains you, make them aware that you have approved VAWA status and show them your work permit, your EAD. Show them your work permit with your VAWA status. If you have evidence that you also have approved deferred action, please show them that. I would suggest you renew the deferred action, but also know that having the approved VAWA status is also a helpful tool against being arrested and detained by ICE. So whether you have deferred action or approved VAWA, it's a very legal distinction, but deferred action, is like, it's like an extra layer to the VAWA approval. Show them both if you have both the approval notice showing deferred action or your work permit with deferred action, and also show your VAWA approval notice. Sometimes they're all on the same paper, and your work permit will show that you have deferred action already. But what we see sometimes is that folks have a work permit with the approved VAWA status, and then they just have a document saying deferred action. So if you can carry both on you, I would show that to the ICE officer if you are facing detention and making it clear that you have VAWA status. There you go. I'm looking at other questions now. So I see a question about military parole in place. So there are certain requirements for military parole in place. I'll go over those quickly. But the big thing is that if you have a family member who serves in the U.S. Army or who has served in the Army in the past, you may qualify for military parole in place. So it's certain family members, it's not just anyone. So it is a child over 21 or a spouse. So if you have someone serving in the military, you may be eligible. There are certain factors that may complicate your case. So I do suggest that you call our office to get a more detailed consultation and evaluation on your eligibility for parole in place. I see a question about like having a criminal history and requesting parole in place. It depends on what happens with the criminal charges against you. If there was no conviction, there may be no issue. But if there were convictions, we would want to look at that case more closely to see what happened and how that impacts your eligibility for parole in place. But yeah, parole in place, for those who don't know, military parole in place, that is an option for folks who have certain family members who serve in the U.S. Army or Armed Forces and who they can have a family petition by that family member, and then they don't need to leave the U.S. They can stay in the U.S. in order to complete the process for residency. So it is a very nice benefit to allow someone to apply for residency. There are certain details we need to confirm depending on each case, because each case is different. Everyone has a very unique background. So we do want to make sure we're reviewing all the details in your case before we confirm that you are eligible for military parole in place. So please give us a call at our number, 202-709-6439. And yeah, we can give you more detailed advice and a consultation on your eligibility. Okay, I'm looking for other questions. Okay. Yeah, so I'm not seeing too many other questions coming in, so I'll just talk a little bit more about Egan. I do want to share that we are taking removal defense cases. So if you are facing immigration court hearings, or you know someone who you've gotten a notice from an immigration court, please give our office a call. We can help you with your court proceedings. If you know somebody who has been detained, either they can try calling us, or a family member or a friend can call us on their behalf, so we can try to help get them out of detention and figure out next steps on their case. So please give us a call if you have questions or concerns about immigration court, and if you're facing a hearing coming up, we are here for you. Okay. I'm looking to see if any more questions have come in. Not seeing. So I see a question about someone who won a cancellation case in removal proceedings, I understand. So a cancellation case in immigration court. That was a few years ago, it seems like. And they're asking about when they will receive their green cards. So my understanding is when you succeed on a cancellation case. So what that means is you made your case in front of immigration court, and the immigration judge decided that you are eligible for residency. So they will terminate your immigration court hearings. So they will dismiss your immigration court hearings. After that, you likely need to take further steps to actually receive the green card. You often need to file a form with USCIS, so you may want to check on that. You can certainly call our office at the number on the screen, 202-709-6439, and we can do an evaluation of your case and give you some answers and a consultation on that, and we may be able to assist you on getting your green card. Yes, so usually after immigration court, even though the proceedings are finished and you don't have to go to court anymore, you usually have to take some additional steps, some additional paperwork to get your green card or whatever documentation you need to prove your status. The immigration court is separate from USCIS, which is the office. USCIS is the office where you apply for residency and you're not in immigration court. So yeah, the court will finish their part, and then you need to go over to USCIS to actually get some documentation. Okay, let me see. Okay, I'm not seeing any other questions right now. I will be signing off in just a few minutes then. Again, my name is Attorney Alex. I'm supervising attorney here at Egan Immigration. I am here to answer questions. I will be doing these lives every week, ideally, and maybe more than that. I want to answer questions, make sure I'm hearing, issues that our clients or potential clients are seeing. So please watch out for our lives, and we're here for you. If you have questions about your case specifically and want a more detailed answer, other than the general answers I can give here, please call our number at 202-709-6439, and we can give you a free evaluation and consultation. And just really want to emphasize that we are representing, we're helping clients on family petitions, humanitarian cases like a VAWA or a T visa, U visa. So if you've been victims of serious crimes or trafficking, we do work on those cases. Those cases I know that being a victim of trafficking, that sounds very, very big, very like, oh, I can be a victim of trafficking. You might think that, but a T visa for victims of trafficking can be available if you've suffered labor problems, so problems at your job, you've been mistreated by an employer, or if you've suffered problems with your partner or a family member, you may be eligible for a T visa. So I really encourage you all to give us a call to do an intake, an evaluation, and consultation to see if you qualify for those. You might be surprised, about the problems you've experienced in your life with an employer at a previous job, or maybe problems with a partner, or in your travels to the U.S. You may be eligible for a T visa, and we want to help you find out if you are. So we work a lot on those cases. We are experts in VAWA and T visas, U visas. So please give us a call. We are also helping folks in removal proceedings in immigration court. So please give us a call if you are facing a court hearing, or somebody who is detained, family member or a friend. You can give us a call, and we can try to help out and figure out how to get them out of detention, how to handle the immigration court. We can be your advocate there. So I will be signing off now. Thank you all for your time and joining me, and we will see each other again soon. Thank you.